22 to 27.
Ah.
In fact, I have received the instruction,
Hmm.
but today morning, my lord, over telephone,
Hmm.
the additional registrar has informed me there is some inherent mistake.
Okay.
So they want to rectify it.
Ah.
Can it be day after tomorrow? Tomorrow will be difficult because some meeting is going on.
Okay,
So I
not
asked-
tomorrow, we'll taking up the next week.
Yes, yes. Any convenient date of
Okay.
this honorable court.
Mm, Mr. Talukdar, Learned Counsel, for the representing the respondent bank, submits that though he has received the instruction, same is not complete and will receive the complete instruction by this week. In view of that, he prays for an adjournment. Prayer stands allowed. List this matter on.
Any day, my lord, subject to lordship's convenience.
Give it.
Instruction will come within
Yes.
2 days.
27th.
27. Correct.
Okay, 27th.
Obliged.
2019 criminal matters, criminal judicial matters, day after two.
Just wait for some time. We'll get it listed. We'll repeat this prayer next week. So we are just trying to streamlining these things. Yes.
Item number 16, I'm appearing on behalf of Ms. B. Chaudhary,
Huh.
the amicus in for respond number 2.
Huh.
She's out of town for some medical emergency. This matter may be taken up after 4 weeks.
Item number,
16. I've taken the consent on the other side.
I am appearing for the appellant, please.
just a minute. Item number 16. Okay, amicus.
Yes, ma'am.
You are
I'm for
MS
B.
Bormon for B. Chaudhary for legal aid counsel. It is submitted that MS B. Chaudhary, legal aid counsel representing respondent number 2, could not remain present due to some medical emergency. Accordingly, a prayer for adjournment is made. Prayer stands allowed. They are inside jail.
They're inside jail appeal.
Jail appeal. No IN.
No,
Already 7 years over.
Till first week of December if possible. Earliest. She's out of town till 27th or 28th. Her letter of absence is there on record.
Give a date. 10th of December.
May not be 10th, 12th or 11th or 12th.
11th. 11th of December.
Obliged, ma'am.
May I please, your lordship, I beg to mention item number 17.
17.
Yes, your lordship.
17 is together. Oh, no. Sorry. Okay. Yes.
Your lordship, I am for the appellant.
Hmm.
The Mr. KP Phatak has been appointed as the amicus curiae due to some personal difficulties. He could not appear before this.
When? When is his brother's marriage? Tomorrow?
Oh.
When is to be fixed?
No, after 26, any day.
Yes, Masumi, give a date. Give it on 10th only, December 10th. 10th of December.
Much obliged.
May I please, the Lordship? Lordship, I'm praying for listing of a 2016 matters, Your Lordship. Criminal revision petition. It last came up on 27/1/2017.
Wait for some time. You may repeat this prayer next week.
Okay.
This matter may kindly be taken up at 2, my lord.
2 or tomorrow? Tomorrow?
One hearing matter in
Yes.
revision matter.
Okay. On the prayer of the learned additional public prosecutor, list this matter tomorrow.
Obliged.
Yes, Gogoi.
73 days is specified behind the bar. Is
Yes.
all suspect. Co-accused.
Co-accused is a different context altogether. She was a lady, just she was roaming around, therefore she was suspected. Now what is his involvement?
My lord, from the entire case, your lordship may kindly peruse the statement of the son of the, my lord, deceased.
According to the relatives, this lady is not involved.
Yes, my lord,
That
regarding lady, but regarding the present Bijoy Sahu, the statement of the son.
Let us see.
Yes.
How many days you are behind bar?
73.
Huh?
73 days.
And one note of the IO is also there, my lord.
What the postmortem report says?
Postmortem report, my lord, head injury, man.
Head injury by weapon.
Yes.
He was alone. Victim was alone in the residence.
Yes, man. Definitely. The earlier the present petitioner's father has sold the
Sold the land to. Nobody's seen him also last together.
No.
Let him go. Ultimately. Hard. Defense of Paris. Interrogated. Advanced stage interrogation. Considering period of detention. 7 months. Allowed. To the satisfaction of?
CJM Biswanath sir.
CJM business. Yes, that is it. Yes, where is Mr. Dhar? Yes. Yes, Mr. Bhattacharya. Huh.
Lord, the judgment which your lordship referred to,
Hmm.
that has been under review now.
That's correct.
But anyway, my lord, I will try to show that is not applicable to this case.
Yes.
In fact, my lord, since your lordship expressed lordship opinion, that's why I didn't go through the main petition. But there are two things.
Hmm.
I have two limbs of argument.
Hmm.
One is that there is no reasonable grounds
Hmm.
to apply PML case.
Hmm.
Secondly, Article 23.
Hmm.
Lord, if your lordship permits me, Article 23, I will argue next.
Yes, I
First,
think
I
so.
will-
Better, that is better. If we are satisfied with the first argument,
Now, your lordship would kindly take the act.
PMLA. Money laundering.
I was thinking of Miller, an appropriate case to challenge this.
Hmm.
But unfortunately, the way it has been challenged, the entire act, the Supreme Court, I don't think the real points are at all covered, subject to correction. Miller. Whenever the constitutional provisions are applied, that gets the priority.
Hmm.
Now, Miller, Article 23,
Hmm.
there is a big purpose behind it. If we go to the speech of the Constituent Assembly, British did not give us this, though they had their. So your lordship will find the 22(3), there are 3 clauses. Now, I don't know, in order to,
Just a minute.
consider one,
Constitution.
I'm just giving the background.
Yes, yes.
Article 20.
Hmm. Yes.
Protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subject to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offence. This is number one.
Hmm.
Number two, no person shall be prosecuted and punished for the same offence more than once. I personally feel, my lord,
Hmm.
this should have been one of the limb of argument. Because I don't know, at least so far I am concerned, I'm in a, my lord, great difficulty to understand this law. There will be two cases.
Hmm.
One is PMLA case, one is, I'm not urging all those things, only for the purpose
Yes,
of understanding.
yes, understand.
And other offences, IPC, Prevention of Corruption
Corruption.
Act. Now, in our case, Prevention of Corruption Act trial is going on. We are appearing there. We have all argued almost 11 witnesses. Now, the Supreme Court says, in one of the cases, that if I get an acquittal in that case, PMLA case automatically, what is this logic? PMLA case, that is why we have so much halla-gulla in the country, political background and all that. So even if I committed an offense under PML, but here if I quitted, I've not been able to, I'll look forward. Then, my lord, we are concerned here, no person accused of any offense shall be compelled to be a witness against himself. First ingredients, my lord, I have to be an accused. I don't know how my learned friend viewed it. We say that if this I am yet to enter defense in my case. If I disclose all those things, then my defense will be prejudiced. So, but I have to be an accused first. Then only this will be applicable. In those cases, subject to correction, my lord, I don't find that this matter was decided after a man has been accused in a particular. Prevention of Corruption Act is a substantive offense. And with the existence of CBI, the Prevention of Corruption Act, PMLA you have brought in. How will you reconcile? These are very important things, and my almost all the learned juniors are bothered about PMLA and all that. None reads it, none applies its mind. What for PMLA has come? First thing, my lord, they said that properties, money, or whatever it may be, it must be a proceeds of crime. They have applied in their complaint that whatever is seized by the Chief Minister's sale, this is a proceeds of crime. Who are you to say that? Is it not the power of the judiciary taken away? Unless your lordship gives me a finding that it is not a proceed of crime. There may be cases, few and far between, that without being a proceeds of crime, because Prevention of Corruption Act doesn't want a proceeds of crimes. This particular clause has disturbed us a lot. What should you understand? I'm sorry to say that most of the judges and the lawyers feel they presume proceeds of crime on which
Reason
they,
to believe. Reason to believe.
Reason to believe.
Reason to believe.
so they don't think
Difficulty is this, Mr. Bhattacharya, that reason to believe, then provisional attachment, then final attachment, all are being given approval by the Honorable Apex Court in that case.
that is true.
That is,
But that does not matter. Your lordship may not rely on it. That doesn't indicate that we cannot debate it.
debate we can do,
Yes.
we may enlighten, but to how far
No,
we
no.
can,
Lord, if I say
Hmm.
that I am going to rely on this decision, Supreme Court said, no,
Hmm.
your lordship will not hear me.
Hmm.
But I have got every right to say this is a wrong decision.
but you have every right to say wrong decision, but to be within the judicial discipline.
No, I am not asking your
That's-
lordship not
that
to
is-
rely on that
yes.
unless because why it has been effort for it.
Because basically this was the fundamental thing was
It
that
will-
without any conclusion of a determination, you are presuming or only on your belief, reasonable belief, that these is a proceeds of crime, you can proceed simultaneously. So argument was that you cannot do it because you are without determination. Yes, it can start after I was convicted under the offense, then the proceeds of crime can proceed.
No,
But
not-
this has been negated.
Not only that, Miller. You want a case,
Hmm.
separate case.
What is the they are saying that you have a chance before the authority, and authority is having all right to even say that no, this is not a proceeds of crime or attachment can be closed. This is the argument what I have understood with
Yeah,
reading the
I
judgment.
understand that, Miller. They say how it is cumbersome. In one of the cases, they can say that authorities are not police officers. So I say.
Hmm.
So, section 25
Hmm.
is not applicable.
Hmm.
Who is saying for 25? Why whisper about 25? How the 25 comes? Some say that one of the case has to be explained or decided. One say. But how did 25 comes in my case? There are two cases. One is after the conviction.
Hmm.
The PMLA case will start. That apart, my lord, I last 3 days I have been thinking that how cases can go on the same season. Not a word more, not a word less. Whatever seizure they have made, that is their case. I don't know why there has not been challenged on that. And that has definitely prejudiced us. Those who are a trial court lawyers, they are in great difficulty. Proceeds of crimes you don't define. Why do you don't define? This is the crux of the whole problem. Unless it is a proceeds of crime, you cannot proceed. Secondly, my lord, which my first point, seizure. It goes to in the hand of the court.
Hmm.
I don't have it. How can I launder this?
That is in this case can be because see the provision itself says the source or something like that. In this case, in the whole search sheet, according to them, this is the proceeds of crime. That is with them. So what further is required, whether this process is reasonable. That can be a ground up, or which is not, however, pleaded in this case.
No, we have pleaded.
Pleaded. Okay, fine. Okay.
reasons to believe.
So where is that provision where they can issue you, ask you to do these things? Because in the Supreme Court, they says, no, they have a power, they can do it, you will have, where is that section? Under calling you to produce whatever evidence against yourself. What is that provision?
50.
50.
Power of authorities regarding someone.
What it says, let us understand that section first, because this is the challenge, isn't it? That you cannot do this. 2.1 is that it violates my right under Article 23. And other thing is that everything is with you. This is your allegation. What more? This is not reasonable. You cannot exercise your power. So you have exceeded your jurisdiction. Then a writ court will exercise power. This is the 2 points. Now, say let us
Powers of authority.
just read that section 50. Let us refresh it. Yes. Okay.
Powers of authorities regarding summons, production of documents, and to give evidence, etc.
Mm.
The director shall, for the purpose of section 13,
Mm.
have the same power as are vested in the civil code under the Code of Civil Procedure 1908, while trying a suit in respect of the following matters, namely discovery and inspection, enforcing the attendance of any person, including any officer of a reporting entity, and examining him on oath, compelling the production of records, receiving evidence on affidavits, issuing commissions for examination of witnesses and documents, and any other matter which may be prescribed. The director, additional director, joint director, deputy director, or assistant director shall have the power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under this Act. All the person so summoned shall be bound to attend the person or through authorized agents as such officer may direct, and shall be bound to state the truth upon any subject respecting which they are examine or make statements and produce the documents as may be required. Every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 of the, subject to any rules made in this behalf. The central government, any officer referred to in subsection 2, may impound and retain in his custody for such period or his things fit any records produced before him in any proceeding under this Act, provided that an assistant director or deputy director shall not impound any records without recording his reasons for so doing, or retain in his custody any such record for a period of exceeding 3 months without obtaining the previous approval of the director. Now, if your lordship says, for all practical purpose, section 50 has been made a civil proceeding.
Mm.
Now the Apex Code has said
Mm.
that these authorities are not political.
Yeah.
So they cannot exercise the power of police officer. Now, vis-a-vis your lordship may kindly come to section 5.
Section 5 is important. Mr. Bhattacharya, I can ask him to go for a time. Section 5.
Attachment of property involved money laundering, where the director or any other officer not below the rank of deputy director authorized by the director for the purpose of this section has reason to believe the person for such belief to be recorded in writing on the basis of a material in his possession that any person is in possession of any proceeds of crime according to them, my lord, whatever the police says, that is a proceeds of crime, they are averment in the complaint. Number B, the proceeds of crime are likely to be concealed and transferred or dealt with any manner which may result in frustrating any proceedings relating to the confiscation and such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. Now, my lord, admittedly, am I in possession of those?
Hmm. Two conditions. First is that it is not or and. You must be possession of the proceeds and there is likely to be concealment or transfer.
So, he,
Now, as per their schedule, they are saying this is the proceeds of crime. They identify the proceeds of crime. Moment they identify the proceeds of crime, which has been seized and under custody of the court. Where is the question? This will be the argument.
yes,
Where is the
that
question of my possession and concealment? So therefore, this order of reasonable belief falls on that ground only.
Exactly. That is our first point.
Hmm.
So, consider for the argument, Miller.
Hmm.
I have to because the statute says so regarding proceeds of crime. They have made number of averments that whatever is seized from me, whatever is found in my house, that is the proceeds of crime.
Right.
And they have to, in order, proceeds of crime becomes the result of my criminal activities.
Hmm.
And if your lordship says, if your lordship goes for the Prevention of Corruption Act, there has to be this corrupt practice.
Hmm.
Now, in order to make it, they presume
Hmm.
schedule offense and all these things, they presume that it is a proceeds of crime. All right, you attach it. The moment they attach it, it is in their custody.
Hmm.
The moment police sees this, that is another difficulty. That is in their custody. Who will retain? 180 days, police cannot ask for it.
Hmm.
So there is a 100% possibility of misusing it, collusion between the police and the PMLA authorities, that you go for that. So
Hmm.
which one your lordship will exist? For 180 days, for 180 days, it is with the authority.
Hmm.
And then, my lord, PMLA has no power of arrest. That is why they have brought in the civil proceedings court. Lordship can go into those chapters. Now, if they have got any other property, even if one item, say there are 10 tolas of gold,
Hmm.
which is not seized by the police. It was attached by the. So that gold, so long it is not seized, it will be always with the authority,
Authority.
at least minimum for
180 days.
Now, in order to satisfy the A, I am in position. And this is the sui juris. It is in the hand of the court.
Mm.
With the permission of the court, they had deposited in the treasury. For the first time, I have seen, Miller, in the trial court, that Salan has been produced. The amount of money which you have spent, you are going to produce that before the court. Or some money from the treasury because you have given the challan. And then, unless those things are seen, unless I examine as a defense lawyer, you cannot proceed. These are the fundamental things now in our present system. Miller, last 10, 15 years I have seen, courts are presuming it. Have a grave demands. I am not bothered with your salah. I bothered that note number this and this and this. I want to see. Is it a fake one? Is it a real one? What about the fingerprint on those? Salan will not do. But they have not produced which they have taken as 15,000. 15,000 trap money. They have gone for that. What stop you to get it examined by the experts so far the fingerprint is concerned? Lakhs, crores, and not only that, Miller. Prevention of Corruption Act, it is a subtle position. Once I explain that this money I got, it's a very, very important defense for me.
Mm.
I may be on the bed. My wife may come and say to the court, no, this was the money given to me by my father at the time of my. That becomes a process of crime. Thoroughly illogical. Supreme Court may say, but Supreme Court judgment, Miller, they made it, they have not resolved this. Argument is also not. But still, that's why I will say, I will endeavor, I will not put a tackle before your lordship. I will say that from first point to last point, apply the decision. Still, I am protected by 23. If your lordship, if these facts make out. So before that, my lord, let me show their complaint.
Yes.
And another thing has to say, Lord, I have found such a big case. In one case, my lord, PMLA case in 2011,
Hmm.
they detected I became accused in 2009. Is my lord very face of it? It is unconstitutional.
Hmm.
In this big case, I have read somewhere. 2009, this process of crime was detected by them, and then 2011. Now, my lord, page 58,
Page 58.
Annex 12. In exercise of authorization dated so and so, issued by the Director of Enforcement under subsection 1 of section 5, Prevention of Money Laundering Act, read with notification number so and so, Save Doyle Chan, Joint Director, Director of Enforcement. Whereas I have carefully gone through the following records, documents placed before me. Just your lordship will kindly see. FIR along with the written complaint dated so and so of the complainant. Seizure list dated 28/3/2017 in respect of the seizure so and so. This is a trap money. Charge and seizure list dated so and so in respect of seizure of amount from the drawer of office table of Sri Kujendra Daloi. 4. Charge and seizure list dated in respect of seizure of from the steel almirah kept in the cabin of Sri Kujendra Daloi. Charge and seizure list dated so and so in respect of seizure of 11,25,000 from the residence of the Sri Kujendra Daloi. Charge and seizure list dated 28/3/2007 in respect of documents seized from the residence of Sri Kujendra Daloi. Charge sheet number so and so against Sri Kujendra Daloi. ECAR recorded against Sri Kujendra Daloi by the Guwahati Zonal Office Enforcement Directorate, Guwahati. Statement of account number so and so, Axis Bank, Guwahati, in the name of Sri so and so. Statement of Sri Kujendra Daloi recorded under 50 of the PMLA in judicial custody. Statement of Sri Minal Kumar Gogoi recorded under section 50 of the Prevention of Money Laundering Act and so. Statement of Rakibul Islam recorded under section 50 of the Prevention of Money Laundering Act so and so. Whereas the Vigilance Anti-Corruption Bureau, Guwahati, thereafter referred to as ACB, received a written complaint dated so and so from Sri Prakash Ranjan Borua. Then, my lord, I'm not reading all those things. 4. Whereas the ACB officials also recovered and seized an amount of so and so. Then paragraph 5. Whereas further charge and the steel almirah kept in the chamber of so and so. Whereas officials conducted charge and residential premises of Sri Kujendra Daloi situated at so and so. Whereas ACB filed charge sheet number so and so dated so invoking section 7 the PC Act in the Special Court, Guwahati. It is seen from the charge sheet that during investigation a prima facie case under section 7 the 2 of the Act has been found well established against Sri Kujendra Daloi, demanding and accepting illegal gratification and accumulating an amount of 54 lakhs through corruption. It is mentioned that the charge sheet that investigation, the case being continued as provided under section 173(8) of the CRPC. Below on the date of settlement, attachment, that case charge was terminated. Then, my lord, whole thing I need to read. You just give me a point out. Page 64,
64,
paragraph 14.
paragraph 14. Yes.
Whereas, from a careful consideration of material placed before me, I have reasons to believe that Sri Kujendra Daloi has accumulated huge money by abusing his official position in respect of which the ACB investigation is progress of Sri Kujendra Daloi in his statement recorded under section 50 gave evasive replies with respect to the source of acquisition and huge Indian currency seized by ACB from his office cabin as well as residence. This clearly establishes that Indian currency of rupees 54 lakhs seized from the office cabin as well as residents of Sri Kuchendu Roy are accumulated by Sri Dolu by abusing his official position and are nothing but, this is not sweeping things. Can it be said only from here that the proceeds of crime? The detailed proceeds of crime involved in the offense, money laundering, offense of money laundering is as follows. This is very important.
Mm.
The money laundering, they have come to the conclusion because of them. Indian currency, 3 lakh and odds. B, Indian currency 39 and now seized by ACB. Indian currency is by ACB from the residents of the country. That number shown. Paramount Greens, VIP Road, Guwahati. As the above are proceeds of crime in terms of section 2A, generated directly as a result of criminal activities and indulged in activities of money laundering in terms of section 2000P. These money at so-and-so as discussed above are with ACB. They are admitted question.
I have marked it.
Then which has filed third sheet number of special case number 22. Reserving the provision for filing supplementary search sheet. The above said movable properties seized by ACB being proceeds of crime are subject to adjudication and confiscation under provisions of the other. I have reason to believe that above and movable properties are likely to be concealed. On likely to be concealed, can you generate reasons to believe?
No, even if likely to be concealed, who will conceal it?
Yes, it is with you.
So does reasonable belief, there must be a reasonable belief, because an stringent act, a power has been given to an authority. So they must have record their reason to believe. Now how can there be a reason to believe that it will be concealed by you when it is under your custody? That is absolute non-application of mine.
All over the country, that's it, including great man. Your lordship must have seen in the paper. Kejriwal had to pay to the court to allow him to take into police custody by the anti-corruption, CBI. Don't know, my lord, what is happening. Now, my lord, pausing for a moment, let my learned friend explain that.
My lord, let my senior finish.
I stopped short for this happening. Then last paragraph. Now therefore, I order that movable properties mentioned below in schedule of properties are provisionally attached under subsection 1 of section Bill Laundering Act for a period of 180 days, and further order that the same shall not be removed, part with or otherwise dealt with without prior permission of the undersigned. Their own documents say it is in their. It will be wastage of time if they do not. Lord, your lordship may come to one aspect, your lordship wanted to see the pleading. Paragraph 22. That the petitioner states that the order of provisional attachment.
Space,
15.
page 15, paragraph 22.
That the petitioner states.
Yes.
that the petitioner states that the order of provisional attachment can be issued only in respect of the property that is in possession of a person accused of a schedule offence. In the instant case, the alleged proceeds of crime are already in custody of the ACB authority on being seized in connection with ACB PS case number, the Prevention of Corruption Act, which is pending in the Court of Special Judge Assam. Thus, there is absolutely no scope for the petitioner to conceal, transfer, and or deal with the seized money when the same are in custody of ACB authority. It is therefore stated that very two conditions as provided in 5(1) of the code is in possession of any proceeds of crime, and that such proceeds are likely to be concealed, transferred, or dealt with in any manner that may frustrate any proceedings relating to the confiscation of such proceeds of crime under this chapter are not attracted in the instant case. And as such, the impugned show cause as well as the proceeding are illegal, arbitrary, and unreasonable, and liable to be interfered with by the honorable court. 24, 25 is the same, my lord. Then your lordship may kindly come to.
Paragraph?
23, 24 will.
Yes, that I've seen.
Your lordship may kindly come. Twenty-six, we have said about the fundamental right. I will address separately on that.
Yes.
But if I succeed on this line, then Miller, I need not. And this may not be a very big case. I bring it to your lordship notice, paragraph 26. That the petitioner submits that he has been charged for commission of an offence under section so and so Prevention of Corruption Act, which is under trial in Court of Special Judge Assam Institute. However, by way of impugned show cause notice, the petitioner has been asked to indicate the source of income, earning, and assets out of which or by means of which the petitioner has acquired the alleged property attached in terms of section 5(1) of the Prevention of Money Laundering Act, and the evidence relied upon. In such circumstances, if the petitioner is required to reply to the impugned show cause notice during the pendency of the trial in the Court of Special Judge Assam, Guwahati, the same would amount to disclosure of the defense of the petitioner, which would cause severe prejudice to the petitioner in the trial. Moreover, it is evident from the records that investigation is being continued by the ACB authorities, and they have sought permission for filing supplementary charge sheet in the case initiated under the Prevention of Corruption Act. As such, the filing of the reply to the impugned show cause notice would jeopardize the defense of the petitioner in that trial, which would tantamount to denial of petitioner in his fundamental right of equality before the law and equal protection of law. Thus, the impugned show cause notice being violative of the provisions of Article 14 as well as 20 and 21 of the Constitution is liable to be set aside and quashed by the Honorable Court in the interest of justice. When I file a bail petition, prosecution immediately stands up and says that we have to file objection about this. Such a serious allegation. Nothing, no records. So your lordship, if your lordship permit me, I would advance that or let him satisfy that.
Yes, first point. Yes.
My lord, for the purpose of just getting into the thing, my lord, I'm just reading the act once again.
Yes,
My lord will take section 3,
section 3.
my lord. Section 3, my lord. Offense of money laundering, my lord.
Offense.
whoever directly or, my lord,
Yes.
whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use and projection or claiming.
Hmm.
It is untainted property shall be guilty of offense of money laundering. So basically, my lord,
Hmm.
this is what money laundering, my lord,
Hmm.
proceeds of crime is defined here, my lord.
Hmm.
So, my lord, then comes, my lord, the next page, my lord. I'm reading from here, my lord, the explanation part.
Hmm.
A person shall be guilty of offense of money laundering.
Space. Explain.
Same,
Yes, yes.
continuation, my lord.
For removal of doubt.
For removal of doubt, my lord.
Hmm.
For removal of doubt, it is hereby clarified that
Hmm.
a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following process or activities connected with the proceeds of crime, namely concealment, possession, acquisition, use, projection, and untainted property, claiming as untainted property.
Hmm.
In a manner whatsoever, the process or activity connected with proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted money or claiming it as untainted property in any manner whatsoever.
Hmm.
So basically, my lord, this is what, my lord, offense under money laundering, this proceeds of crime, my lord, we can understand, my lord. Now here is the case, my lord. If my lord goes to page number 58, which
Page-
my senior has just, my land senior has
Page
just read, my
58.
lord, of the writ, this petition, my lord.
Hmm.
Our provisional attachment order, my lord.
Yes.
The seizure, my lord.
Hmm.
My lord, this is the seizure. My lord, my senior has already read my lord, the list.
Hmm.
What are the contents?
Hmm.
What was found in this position?
Hmm.
So, my lord, now it is in a trial stage.
Hmm.
Whether this whatever recovered, my lord, the amount of money, 54 lakhs, some properties and bank accounts, whatever, my lord,
Hmm.
whether these are proceeds of crime or not, my lord, that will be dealt by the learned court below, my lord. It's in trial, but we have a reason to believe, my lord, that this property, whatever was recovered, my lord, these are proceeds of crime.
No, that is fine. That is fine. There is no problem on that.
My lord.
You have, this is a procedure of crime. For the time being, let us
Yes,
assume it.
yes, my lord.
Now, let us understand what section 5 says. Under what circumstances you have been given an authority and power to attach provisionally.
Yes.
Provisional attachment will come when there is an urgency, so that you don't have time to, that may be concealed immediately. So you have a, what with my limited understanding.
My lord.
So that power has been given to an authority, which is an extraordinary stringent power,
My lord.
to attach provisionally a property which you have reason to believe that this is a tainted money,
My-
or it is likely to be concealed or
My-
transferred.
My lord.
So situation is such that you don't have, if you wait, that it may already be concealed or transferred. Therefore, you must have a reasonable belief to that extent that it may be concealed, transferred, etc., etc.
My lord.
On that basis, let me rephrase it because I want to understand the law first.
Yes, my
So
lord.
therefore, in that circumstances, you have been given a power to attach provisionally, but legislature in wisdom has said you cannot do it beyond 180 days.
Yes,
And
yes,
within 180 days, certain procedure has been prescribed
exactly,
to do in a certain manner.
exactly.
Therefore, first let us understand whether there can be any reason to believe that it will be concealed or transferred when that property is under custody of an authority or under law. Maybe investigating authority, maybe court, maybe you.
Yes, my
whosoever.
lord, court is a court, my lord. It's always
Okay.
honorable. court.
So what we want to know, because reason to believe must cannot be an empty formality. In so many judgment it has been said. You may not say all the reasons, but it is not an empty formality. Now we want to understand in a given facts of the present case, where that property admittedly this is the property, and you have not attached anything more. Within your knowledge, there is no other property beyond this property that may be likely to be concealed. So this is provisional attachment.
My lord. This is the provisional attachment, my lord.
Okay,
No,
this is
we-
gone.
we-
Now,
We could not confirm it because it has to go to the executing authority
no, you have done it provisionally
provisionally.
because of the apprehension that it may be concealed immediately. It may be transferred immediately.
My lord, here is the case. Why you do it, my lord? Sometimes it happens so, my lord, that there are simultaneously two
No,
proceedings.
Mr. Dhar, please argue within the bound of the provision. What you do in certain cases, we are not concerned with it. We are concerned with what the law asks. Since this law has been upheld and it is very stringent, we will proceed in that manner. Now, please tell us what and when you do what manner is not our concern. Our concern is in this case, when these properties were there, whether there was an reason or an condition precedent to exercise your power to provisionally attach. Let us see whether your provisional attachment order, what is your reason to believe? That is in paragraph 14. You have otherwise recorded so many things. Paragraph 14. This is the reason to believe.
Yes, my lord. Whereas upon a careful consideration of the materials placed before me, I have reasons to believe that Sri Jole has accumulated huge money by abusing his official position in respect of which the SCB investigation is progress. In his statement recorded under section 50, PLMA gave evasive replies with respect of source and acquisition. My lord, this is.
Now, please tell us where is your reason to believe that it is likely to be concealed, transfer, or dealt with any manner which may be result in frustrating the proceeding. Please show us from your provisional attachment.
That has to date.
Will for the time being, your position is admitted. Now tell us that your reason to believe must ask that I have a reason to believe that he may conceal it, he may transfer it, or deal in a manner which may result in frustrating the proceeding. Where is that reason? Please let us understand. Which paragraph? Because paragraph 14 now, after careful consideration, because the other paragraph prior to preceding paragraph prior to 14 are the facts. On that facts, you have a reason to believe it, which is contained paragraph 14. Now tell us where is that belief as regards concealment, transfer, or dealt with any manner. See at page last line
Yes,
after PMA. I have reason to believe.
Yes, madam. I have got it, madam.
Okay, now suppose you have done it correctly. Fine. Let us assume for the time being that you have done it. Now your duty is to forward it to the adjudicating authority.
Yes, madam.
Now what is to be done by the adjudicating authority?
My lord, once we
You have provisionally attached it
At-
within
attached
180
it.
days. You
He
have,
will either confirm it or my lord release it.
no, who will confirm it?
Adjudicating authority,
Adjudicating authority.
authority, my lord.
Now let us, what is the responsibility of the adjudicating authority? Let us see under the statute.
Yes, my lord.
That will be, I think, under section 7,
Yes, my lord.
section 6 and 7,
six and
section
seven, my
7,
lord.
8,
Eight.
section 8,
8 is the my lord
adjudication.
adjudication. My lord. On risk,
So you have filed a complaint under section 5, subsection 5.
yes.
That is also there.
There.
Okay. Now let us understand what section 8
On
says.
receipt of a complaint under section subsection 5 of the section 5 or applications made under subsection 4 of section 17 or under subsection 10 or section 18, if the adjudicator has the reason to believe that any person has committed an offense under section 3 or in a possession of proceeds of crime, it may serve a notice or not less than 30 days on such person calling upon him to indicate the source of his income, earning or assets out of which or by means which he has acquired the property attached under subsection 1 or section 5.
Okay, let us now understand what he can do. So you will ask the indicate the source of his income, earning or asset
Yes.
out of which or by means of which he has acquired the property
Mm.
attached under subsection 1 of section 5.
Mm.
Okay.
The evidence or
Mm.
he relies on relevant information particular
Mm.
and to show as to why all or any of such property should not be declared to be properties involved in money laundering and confiscated by the central government.
Mm.
Provided that
Mm.
where a notice under this subsection specifies any property as being held
Mm.
by,
That is as regards to third party.
yes,
Suppose I say that Mr. Dhar is having this property
Mm.
on behalf of this.
yes,
This is not applicable in this
is
case.
not applicable, my lord, provided jointly, my lord. So, my lord, this is second is, my lord, provided that where such a property is held jointly by more than one person, such notice shall be served upon to the holding such property. The tribunal shall considering the reply, if
Mm.
any, to the notice issued by the under section, hearing an aggrieved person, the director, or any other officer authorized by him, taking into account all the relevant materials placed or record before him by an order record finding. Basically, my lord,
Yes.
so basically, my lord, he will be given a chance there.
Mm.
Both the parties, they will appear, my lord.
Mm.
Adjudicating authority basically is, it's a court, my lord.
Mm.
So both the parties will be, my lord,
Mm.
will be given a chance.
Mm.
Principle of natural justice will be there.
Mm.
And, my lord, ultimately,
Mm.
the adjudicating authority will pass an order.
Mm.
If somebody is aggrieved,
Mm.
he will have a, my lord, chance on appeal in the tribunal.
Mm.
And then, my lord, before the High Court. That is what the statute
That
says.
is your argument on the first day also.
Yeah,
You
no,
are
that-
saying that this is not end of the matter. He can still
this is
go.
basically the
He's,
axis.
he can go, he will file reply.
He may not
and
also. He may refuse.
may
also.
not, he may refuse to file
This
reply.
is
also.
civil proceeding.
He may refuse to file and thereafter they may proceed. So
Proceed.
therefore, there is no cause of action for, he will not be aggrieved because
is-
he has a right not to file a reply.
Reply
But
also.
how will conceal with section 50 and section 8? Section 50 says he is bound to do it.
Bound to do it before, my lord, that is before the director, not before the executive authority.
Now, this has been issued by the
This is by the executive authority, my lord.
adjudicating authority.
That is the court, and director, my lord, he has, that is bound.
Because he is
Section
not
50.
not a police officer, therefore Supreme Court says that this is nothing.
Ah.
Anyway, okay.
But
Sure.
this is executive authority, my lord. Supreme Court says that he have to go. That is what, my lord, in 161, in this Madanlal judgment, my lord,
Mm.
Supreme Court has defined this two proceeding,
Mm.
criminal and civil.
Civil.
So this is basically civil proceeding, my lord.
Mm.
He can go. He may say, I don't want to disclose anything.
Okay. So therefore, according to you, this communication by the adjudicating authority
is correct.
will not hit his right under Article
Article
23
20.
because he has no compulsion to disclose. This is your argument?
This
Yes.
is, my lord.
Yes,
This is a basically civil proceeding, my lord. He may not.
he may not. So this is a notice under subsection, notice under subsection, there's under 7, under 8,
Under 7.
under 7.
7, my lord.
Where is that notice? Please let us see. Section 5, subsection 5. No, this is notice under section 8.
Section 8, my lord.
So according to you, section 8, he
They
has
are-
no compulsion,
they are-
therefore there is no violation of
They
Article
are not
20
here before
within
because of
bracket 3.
section 50.
So
They
let
are-
us just understand. So according to you, there is no question of violation of any right under Article 20 within bracket 3 because under section 8, there is no compulsion to answer.
My lord will just come to page number 19
Case 19.
of the petition, my lord. What is their prayer, my lord?
No, prayer technical, don't go to the technical
No, no.
right now.
My lord, this is vital or else, my lord,
Yes.
there is no need of prayer in the petition.
Yes, where is that? What is the vital?
19, my lord.
Yes.
First is A, my lord.
Hmm.
Declaring the action on the part of the respondent authorities in issuing show cause notice
Hmm.
dated 26/10/17
Hmm.
and Annexure 14 by the Registrar Administrative Officer
Hmm.
executed under section 8.
Hmm.
They are basically aggrieved by this section 8
Ah.
petition.
Section 8.
Section 8, my lord. This is not
And a complaint proceeding. At paragraph C.
setting aside the quashing the impugned complaint proceeding
The entire proceeding they want to set
of
aside.
of the adjudicating authority, my lord.
Ah.
That is the same.
No, one
Before
is
the
notice,
Section.
one is notice,
uh,
and other is the entire proceeding be pending before the adjudicating
authority.
authority.
Ma-
So
I'll-
according to them, whole should go.
Yes.
Because their whole ground is that these are two simultaneous proceeding affecting my right. And you are prosecuting me for the same offense twice by simultaneously.
My lord.
This is their argument.
So basically my argument, my lord, I am going by the prayer, my lord. They haven't, my lord, amended
Understand?
amended their petition, my lord.
Hmm.
As of today, my lord, so far I understand, my lord.
So can I now just summarize your argument, what I
My-
have understood,
my
because that is important for me also.
My lord.
Your first argument is that whatsoever the provisional attachment is done so far relating to their prayer, according to you, provisional attachment or attachment order is not under challenge. This is one. Second thing is that what is challenge is under subsection 1 of section 5 as we 5 under by which he was asked to answer. According to you, 2610 is page 68, isn't it? 26 is just under section 8, though they have written in present. Okay, so under section 8. So according to you, this will not a violative of Article
That
20.
is the Supreme Court also says, my lord, in para 159 of the
So that is
Bandhalan judgment.
that I have seen.
And my lord, here in para 161, Supreme Court has defined, my lord, these are two proceedings. One is civil, one is criminal, my
Okay,
lord.
so then let us understand your argument. So this is therefore there is no case is made out, therefore it should be dismissed. And if they can appear and if they are having any grievance against any decision of the authority, they have a right of appeal before the tribunal, and if against the order of tribunal, they can prefer an appeal before this High Court
High
under the Act. So therefore, this petition should not be attorney. This is your case.
Yes, basically this is my from day one.
Yes.
This is limited argument, my lord.
Okay. That's all.
That's all, my lord.
Yes, Mr. Bhattacharya.
Their affidavit, Your Lordship.
Affidavit. Yes. 10/1/2018.
And
19/6/2000. No, that is reply by Prasanna Kumar Naik.
Prasanna Kumar Naik.
Okay.
Prasanna Kumar Naik.
Okay, this is, there is no date. Okay, anyway, I have got it. Yes,
Your Lordship may kindly come to page 7.
page 7. Yes. 8 and 9. Just a minute.
Very first line. Read it.
Hmm.
This clearly establishes that Indian currency rupees so and so is from the office cabin and residence of the petitioner.
Paragraph, which paragraph, Mr. What?
17.
Oh, 17. I was
Page
getting.
7.
Okay, just a minute.
Continuation of 7.
Okay, just a minute.
Lordship got it.
Yes.
This clearly establishes that Indian currency rupees so and so seized from the office cabin and residence of the petitioner is accumulated by abusing his official position. The Indian currency of so and so seized from the office cabin and residence of the petitioner, being proceeds of crime, is subject to adjudication and confiscation. It is a fact, just see below this line.
Hmm.
It is a fact that amount is lying with the ACB.
Hmm.
There is apprehension, not reason to believe. There is apprehension that the seized money, which is proceeds of crime and involved in the offense of money laundering, may go into the hands of the petitioner without the knowledge of the enforcement directorate and may frustrate the proceedings under PML. As such, the provisional attachment of the proceeds of crime was warranted and accordingly was based to ensure that the proceeds of crime is available. As person on the court, and he is in the court. How it will come to me? And if so happens, my lord, if that is their apprehension, they can appear before the court. This, my lord, reason to believe, and the money is in my possession. That is the first ingredient to be followed. And I have to go to Delhi.
Hmm.
You take away my all money and then you ask that go to Delhi. It is fair play by the government of India.
Okay. Hearing concluded, judgment reserved.
That your
Next.
lordship would like to hear something on the judgment.
If you, then it will be our enlightenment also, if you want to address. Maybe.
My lord, one thing just I want to add up. This judgment was challenged in a review petition and there is no stay, my lord.
No, that we understand. Let us see, let us, how Mr. Bhattacharya interprets this.
I'm not going to argue that.
No,
He is not going to argue that. Let us, how
Let us-
Mr. Bhattacharya understands or criticizes this, then let us see.
yes, that will be,
That will be good for
that
us.
will be an education for me also.
Yes, that's why.
That is what I am hearing.
He is from day first,
Yes,
he
my-
is saying that I'm not relying, I'm not saying that this judgment is something. So he's relying, arguing his case on his facts.
No, I reserve the right, my lord, if your lordship is not inclined to give me relief on the first
Yes,
point.
so therefore I want to, I think you should argue also that will be our enlightenment. Let us understand.
Probably that is Supreme today in the judgment. no?
Supreme today judgment. I am also having the Supreme today.
Page 169,
Just that. Page
169,
169,
paragraph 172. madam.
paragraph 172. And you relied on this paragraph 152.
Para 159.
Para
One-
or
159,
159,
161,
161, 152,
no, my lord, 161.
161. These two paragraphs,
Yes, my lord.
159 and 161.
Now, Sri Milord, the article 23 says that I have to be accused first,
Hmm.
which is an admitted position, I am an accused. So whether this safeguard is available to me or not. My learned junior will read it.
Yes, 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 yes. Paragraph, page 169, isn't it?
172, my lord. In fact, my lord, there are. No, but my learned senior is, my lord, facing is that, my lord. He has to be an accused first, my lord.
Hmm.
So in this case,
Hmm.
my lord, the judgments which have been referred to, pursuant to, my lord, in paragraph 154.
Hmm.
Just before taking it to 172, my lord.
154, isn't it?
Yes, my lord.
Yes.
Even, my lord, 153,
Just a minute. 153, page
page, my lord.
158, page number.
150.
Down.
Down, 158, paragraph
153, my lord, start
152,
153.
153. Just a
Well,
minute. 53.
So I'll just, then
Yes,
should come to
yes.
the next page, you know,
Hmm.
page 159.
Ah.
It starts with broadly stated in the guarantee.
Proceeding.
If it is quoted, you know,
Quoted broadly.
broadly stated, the guarantee in Article 23 against this testimonial compulsion, it is such that this is confined to the oral evidence of a person standing in trial for an offense when called to the witness stand. We can see no reason to confine the content of the constitutional guarantee to this barely literal import, so as to limit it to rob the guarantee of its substantial purpose and to miss the substance for this sound as stated in the certain American decisions. The phrase used in 23 is to be a witness. A person can be a witness not merely by giving oral evidence, but also by producing documents or making intelligible gestures, as in the case of a dumb witness. See section so and so. Or the like. To be a witness is nothing more than to furnish evidence, and such evidence can be furnished through the lips by production of a thing or of a document or in other modes. So far as production of documents is concerned, no doubt, section 113 of the Evidence Act says that a person producing a document or summons is not a witness, but this section is meant to be to regulate the right of cross-examination. It is not a guide to the connotation of the word witness, which must be understood in its natural sense. That is referring to a person who furnishes evidence. Indeed, every positive valuation act which furnishes evidence in testimony and testimonial compulsion connotes coercion, which procures the positive valuation evidentiary acts of the person as opposed to the negative attitude of so and so. Now, Lordship may skip. Now, Lordship will just take the highlighted part.
Hmm.
It is available to a person against whom a formal accusation relating to the commission of an offense which has been leveled, which is the normal course, may result in prosecution.
Hmm.
So he has to be accused first.
Hmm.
Now, in paragraph 154, Milord, is in the same lines.
Hmm.
In the case of Muhammad Dastagiri, the court restated that the requirement to invoke the protection of Article 23 is that the person must be formally an accused of the offense. So, Milord, the precondition, Milord, under Article 23 is, Milord, that he has to be an accused first. Now, the same paragraph, the highlighted part, Milord, considered in this light, the guarantee under Article 23 would be available in the present case. This petition against whom a first information report has been recorded as accused hearing. It's not open for all. That is what we are trying to impress, Milord. The paragraph 155,
Hmm.
the highlighted part, Milord, again. Similarly, for invoking the constitutional right against testimonial compulsion guaranteed under Article 23, it must appear that a formal accusation has been made against the party, pleading the guarantee and that relates to the commission of an offense, which is the normal course may result in prosecution. 25. The cardinal words of this section are those which empower the commissioner or his inspector to examine into and report on the affairs of the society. Thus, it is clear that the examination or the investigation, the affairs of the company cannot be regarded as a proceeding started against any individual after framing an accusation against him. Besides, it is quite likely that in some cases, investigation may disclose that there are no irregularities or there do not amount to the commission of any offense. In such cases, there would be obviously be no occasion for the central government to institute criminal proceeding under so and so. Therefore, in our opinion, the High Court was right in holding that when the inspector issued the impugn notices against the appellant, he cannot be said to have been accused of any offense. So the first essential condition of the application of Article is absent. So Here is a case we are accused, my lord. Lordship will kindly come to paragraph 157.
No, 157.
57, my lord, the highlighted part.
Hmm.
Normally, a person stands in the character of an accused when a first information report is lost against him in respect of an offense before an officer competent to investigate it, or when a complaint is made relating to the commission of an offense before a magistrate competent to try or send to another magistrate for trial of the offense. When a customs officer arrests a person and informs that a person of the grounds of arrest, which is bound to do under Article 22(1) of the Constitution, for the purpose of holding an inquiry into the infringement of the provisions of the Sea Customs Act, which he has reasons to believe, there is no formal equation of an offense. So there is a distinction, my lord.
That we understand.
Lordship, even I'll just, my lord, even the next paragraphs also, my lord, the highlighted parts all cover this.
At this stage, therefore.
Lordship, I'll just now take you to paragraph 172.
Now, after discussing all this, how the
Yes,
this
my lord, I'll just-
constitution based
that is my, my lord, Lordship, will kindly come to 172,
172.
page 159.
Okay.
In other words,
Hmm.
in other words, there is a stark distinction between the scheme of the NDPS Act dealt with by this court in Tufan Singh, Supra so and so, and that in the provisions of the 202 under consideration. Thus, it must follow that the authorities under the 2002 Act are not police officers. As consequently, the statements recorded by authorities under under the 2002 Act of persons involved in the commission of the offense of money laundering or the witnesses for the purpose of inquiry investigation cannot be hid by the vice of Article 23 of the Constitution, or for that matter, Article 21 being procedural established by law in a given case when the protection given to the accused who is being prosecuted for the offense of money laundering of Section 25 of the Evidence Act is available not, may have to be considered on case-to-case basis, being the rule of evidence. And in fact, my lord, I'll just But insofar the review is concerned, I'll just
Now, how do you say about his argument that this is a notice under Section 8 by the adjudicating authority, and therefore he has no compulsion or under challenge? He has no, you have no compulsion to give anything. So therefore, the action under challenge in by stress of no imagination can be an action which violates your right under Article 23.
my lord, if that be so,
Just to
Lord,
respond to his
the
argument.
very source
Hmm.
as defined in Section 5
Hmm.
is violated. Unless and until they may have a case, but unless and until they come to a conclusion, my lord, that these reasons. reasons to be
That is true. That is,
So,
you,
because
you want to
ultimately-
say that when the foundation
Foundation is
under 551, we're not there and absolutely illegal on the face of it, and therefore all subsequent actions
Sure.
shall follow.
So, and so, my lord, I'll just take you to the, my lord, although, my lord, there is no stay in the review, but I'll just take you to, my lord, the page 20, well, page 2 of the, my lord, order, my lord,
Review order.
of this, of the Honorable Supreme Court, my lord. This was an order dated, my lord, this was filed in 2007 itself, my lord. My lord, the order, this was on 27/7/2022, my lord, the order of, my lord, this, Vijay Madan Lal. My lord, the review was filed in the month of August itself. And lordship, having heard Learned Singh appear on behalf of the so-and-so, and also the Learned Solicitor General appear on so-and-so, prima facie, we are of the view that at least two of the issues raised in the instant petition requires consideration. Well, two issues, my lord, we could not collect the copy of the, my lord, SLB. But at the same time,
Okay,
two issues, my lord, maybe what we
maybe
are-
these two issues
Yes,
were
yes.
vital. That's all. Hearing concluded, judgment reserved. Gimana sir? Mata order sudah. Yes, Bhagavati.
Except appeal under POXO 6.
Yes,
So respondent-
Borthakur, notices were sent to your office by the registry.
Yes, my lord.
So what is the present status?
Present status, my lord, I have not found any regarding receipt of notice. I will have to again check, my lord, from the OC Saraipur, my lord.
Okay, we are listing it next week.
Yes, my lord.
Office note dated 8/5/2024 reflects that notices to the victim, informant were sent through the office of the public prosecutor. Full stop. Mr. Borthakur submits that he may be granted some time to complete his instruction as regards status of service from the concerned police station. Prayer is allowed. List this matter on 27/11/2024, on which date Mr. Borthakur shall complete his instruction as regard service.
Yes.
List accordingly.
Lord, 5 is also same here.
Same. Same order. Only record his name. Saikya. P. Saikya. Legal Aid Council, huh? And Bhagavati, in case of Bhagavati, it is amicus curiae. In case of P. Saikya, Legal Aid Council.
My lord, item number 6, report of the IO is there, my lord. In that, my lord, report, the address of the victim is shown, he is of Dibrugarh, she is of Dibrugarh district. But a handwritten address of permanent address is there. She is a permanent resident of Dolgaon, my lord.
We'll appoint some Legal Aid Council. For her.
Already legal aid council, my lord.
For her.
Oh, yes.
He is here. But office note reflects that the concerned police station could not found out the informant / victim to serve the notice. Full stop. In view of the aforesaid, let where is the amicus list? Let Swain be appointed as a legal aid counsel on behalf of the respondent number 2. Full stop. Registry to furnish a paper copy of the paper book to the said respondent, to the said learned counsel, and list this matter for hearing on.
On, my lord. Any date, my lord.
This is 2022. Okay,
Judgment was passed in 18, 3 years imprisonment.
already.
Already,
Okay.
but on 18, it was passed, 3 years, punishment was there. By the time it's 2024,
Yeah.
so otherwise it's not so urgent because he's out by this time.
Okay. List this matter on a date we fix by registry,
Deeply obliged, Your Lordship.
reflecting the name of the learned counsels in the cause list.
Deeply obliged, Your Lordship.
So for adding because yes. Matasun, so
Big.
we are ready.
Right.
You are legal aid counsel or for
Lordship, legal aid counsel.
legal aid counsel? Yes, Borthakur, ready? Okay, we'll come back. And what about other matters? Let us see how many matters are there. Call the other matters. We'll take. 9 will have to appoint an amicus. None appears for the appellant on call. It is stated that the learned counsel for the appellant has in the meantime expired. GC Phukan?
That report is also there, here, expired, appellant expired.
No, but there is a substitution. by-
Substituted, my lord.
Uh,
One
so,
order is there.
uh,
my lord.
No, the lawyer also had also GC Phukan. Is alive? Anyway, none appears for the appellant on call. In view of the aforesaid, let B. Prasad be appointed as an amicus to represent the appellant. Registry to furnish the records / papers of the appeal to the aforesaid learned counsel and list this matter once again in the order column after 10 days. after 10 days, reflecting name of Mr. B. Prasad in the cause list. Okay, then 11. Yes, Rashtrabhasha,
Yes.
criminal petition, state. Okay, 11. That matter.
Madam, only one matter left.
Okay, we'll take this up. Then 12, 13. 12 and 13. We'll do it. You'll do it. Okay, 12, 13 gone. Okay, we'll come back then after. Yes. Yes.
In item number 14 and 15,
Uh,
I am appearing in item number 14 as a amicus curiae, Lordship,
uh,
and he is appearing in 15.
Hmm.
Lordship, some difficulty today. Lordship, can it be on some other day, Lordship? I will do that on that next
okay,
day.
2017, we can
Yes.
accommodate. When?
Lordship, any day as per your convenience, Lordship.
The two ladies.
Yes,
Yes.
Lord, yes. Same widow from same widow of the same husband. They are the
And
widows.
these are the
Yes.
elder brother-in-law,
Yes.
something like
They are relatives. somewhere.
relatives. Exaggeration is there, but
Yes.
attack is also there.
Attack, some medical report there are some.
Yes. Anyway, when? 11th of December.
Obliging, Lordship.
Yes, just before that, there is a short matter as regards these criminal petitions. We'll go to that because your decision appeal is not ready. It will take some time. So let us we finish up this criminal petition matters. Yes, Rashtrabhasha first. Yes, say that nothing survives, we'll close it. Isn't it? Nothing survives.
No, I'm for the alleged accused. I have challenged the proceeding
Item 10.
10.
Where is the state council? You have challenged what?
Lordship, annexure 10, page 43,
Annexure 10.
page 43. This is the complaint filed by the Register of Societies before the landed CGM.
Page 43.
43.
What are your ground for challenge?
What happened is, Lordship, this complaint came out of the hearing before the Register of Society, which is at page 36, Lordship.
Complaint is at page
43, Lordship.
43. There are double page marks. No, 43 is something different.
What happened, Lordship? I think, Lordship, the miscase has been placed before this one of the court. Miscase has been filed by the
This is criminal miscase. Give the main case. Miscase has been filed by?
filed by the respondent hearing.
What
for
is their case?
For modification of the stay order, vacation of the stay order. Now, Lordship, they have stopped appearing in the cases. These are the private respondents.
This is miscase. I want the main case.
The main case.
Page 43.
43. Okay, may I read, Lordship? Lordship, got it?
40
Annexure 10.
and acceptance.
May I read, Lordship? Sir, with reference to subject cited above, I have the honor to furnish here with the certified copy of the order dated 8/7/13 passed by Sri Abhijit Dev Laskar, Register of Farms and Societies, Assam, under WPC number such and such, as directed by the Honorable Justice of Honorable Body such and such, dated 26/7/12, and request your honor to take necessary action as per section 4B2 5HT and.
What is that order?
Lordship, this 45 order, Lordship will get at page 24, Lordship,
Page
24. After page 24, relevant portion is page 26. Third, Mr. A. Sharma, Learned Counsel appearing for the petitioner, as well LP Sharma, Learned Counsel appearing for the respondent such and such. In the present writ petition, the petitioners have made numbers of allegations against the Assam Rastrapada Process Committee and functionaries of the said committee of committing various irregularities. Learned Counsel appearing for the petitioner submits that in view of the irregularities, the registration of the committee is liable to be cancelled. The court, however, is not making any observation as regards the state allegation, which has been denied by the respondent. However, this court is of the view that registrars of firms and society can look into the various allegations made by the petitioner in the writ petition and take the appropriate action in accordance with law. Accordingly, the petitioner number 1 and 2 are directed to submit a written representation along with the supporting documents to the registrars of firms and societies within a period of 1 week, and thereafter the registrar of firms and societies, after examining the matter, will pass appropriate order.
Now, where is that order?
Lordship at page 36. The order upon which the complaint has been filed. Page 36 annexes 11. Priority portion is page 37. That's from the third paragraph form.
Now, what is the power and how it can be sent?
If That's they have the power, Lordship. Only thing, as your Lordship found that the basic grievance of the complainant therein was closure of the press. Basically, there's a labor dispute. So that has been dealt with by the industrial court. So taking the grab of this closure of the press, they approach the registrars of society.
And what are the offenses?
Lordship, offenses, Lordship, as per the register of societies, 4A, 4A1 and 4A2 and 4B1. And
What are these offenses?
4A and 4A1 and 4A2, these are not punishable. Only 4B1.
What did it say?
Fine of 500 rupees.
Now, what is the offense? What is called?
Only
Just wrote. So, according to you,
balance sheet and
according to you, 4A1 and 4A2 are not punitive things. So there cannot be any registration, cognizance of any complaint.
Yes.
And second argument is, so far 4B1 is?
Balance sheet and auditor's report not submitted within 30 days.
Okay.
We have submitted, but what the order is, balance sheet and auditor's report not submitted within 30 days since its inception from 1951 to 2003. And from 2003 up to date irregularly at the time of renewal. It is not the case we have not submitted, we have submitted. And
Now, if you do not submit, if you submit beyond 30 days, what is the offense?
500 rupees fine.
And how is to be, fine is to be?
The London CGM will take cognizance after hearing. If I am convicted, then only I have to pay.
Okay, now where is that? Now, after this complaint registered there, what happened?
What the petitioner did, petitioner challenged this order before this honorable court in a writ petition. And may I be allowed to.
Where is that? Now, what happened to that order?
What I'll be submitting, this honorable court diluted the order
Hmm.
and asked us to approach the authority
Hmm.
to place all the record and get the registration done again.
So it was kind of a
It's
regularized.
not regularization,
And what happened thereafter?
it is a recent order, Lordship. What happened in this case, my name was not reflected. We went unrepresented because Learned Counsel Alpi Sharma expired, his name was reflected. We missed. However, this honorable court in our absence also passed the reason order, Lordship. Lordship will find the order at paragraph 13, Lordship. Page 7. Having taken note of the submission made by the.
Paragraph?
13, 1 Having taken note of the submission made the Learned Standing Council and for the finance as well as the Learned Gambler who have both supported the impugned order, this court taking note of the various requirement of Society Registration Act 1860 as amended from time to time by the Assam Amendment Act, the court is inclined to provide that notwithstanding the order dated such and such passed by the Registers of Concerned Society, the said order shall not be a bar for the petitioner society to apply. for.
Heard. Mr. Chakraborty, Learned Counsel for the petitioner. Yes, anybody represents the state? No. Farms and societies. Registered of none appears for the informant, none appear for the respondent. On call, though Mr. Borthakur is present. Full stop. The present application is filed. Present application is filed. Where is that impugned order?
Page 43 and section 10.
Filed. An order dated 19/7/2013, 3/10/2013, 30/10/2013, and 30/11/2013, and the proceeding of case number 2330C/2013 pending before the Learned Chief Judicial Magistrate Kamrup. Full stop. The background facts which are necessary are to the following effect. Full stop. The respondent, what is his respondent number?
Private respondent, Lordship, 2 Lord, 3 Lord.
Respondent, informant is the respondent number 3.
Yes, Lord. The informant will be the registered, Lordship, in the complaint case.
Yes, the respondent number 2. No, not respondent. The who filed the earlier writ petition?
We Lordship, Assam, that petition, I have the original petition.
No,
By 3.
by 3.
By 3.
The respondent number 3 approach this court by filing a writ petition being WPC 4753.
Lordship, 45%.
Huh?
45%.
Where is that order?
24, Lord, page 24. And
Page 24. Approach this court filing WPC 45 of 2010. Alleging various allegations, making various allegations against Assam Rashtra Bhasha Prasar Samiti and its functionaries of committing various irregularities. Full stop. Such irregularities were denied by Assam Rashtra Bhasha Prasar Samiti. That is the present petition.
Lord.
Full stop. This court, without making any observation as regards the said allegations, this court, under its order dated 26/7/2012, without making any observation as regards the said allegations, ask the Register of Farm and Societies to look into various allegations made and to take appropriate action in accordance with law. Pursuant to such decision, the Register of Farms and Societies Assam passed an order dated 8/7/2013 to 2013, relevant portion of which are quoted herein below. Page 38. Green pencil to green pencil. Such decision was again challenged by the Assam Rashtra Bhasha Prasar Samiti in WPC 4753/2013. And this court, under its order dated 4/10/2013, suspended effect and operation of the order dated 8/7/2013. What was that order? That order? Subsequently, such order was extended from time to time. 23/8/2013.
That order I have placed just now.
23/2013. We will come to that later on. Now, prior to that, on 15th of July 2013, the Register of Farm and Societies forwarded the order dated
8/7/13.
8/7/13 8/7/2013 for 8/2013 and requested the learned CGM to treat the aforesaid order as a complaint petition under section 21 (2) of the Societies Registration Act 1860. On the basis of the aforesaid order, on the basis of the said communication, the learned Chief Judicial Magistrate issued summon to the present petitioners by its order dated 19/7/2013 after registering a CR case being case number 2330C/2013. Aforesaid CR case number as well as the orders passed by the magistrate issuing summon has been challenged in the present writ petition. In the meantime, this court disposed of WPC 4753/2013 by which the order dated 8/7/2012 13 was put under challenge. First of this court, the relevant portion of the determination is quoted herein below. Page 13. Page 13. Page 13. Also. Thus, from the aforesaid, it is seen that this court, after taking note of the provisions of law, has provided the petitioners an opportunity to rectify the alleged irregularities committed by them. Full stop. In view of the aforesaid determination, this court is of the opinion that no fruitful purpose shall be served to allow the prosecution that has been lodged on the basis of the order dated 8/7/2013, inasmuch as the order dated 8/7/2013 inasmuch as effect of order dated 8/7/2013 has been modified by this court. Accordingly, the present criminal petition 42/2004 stands allowed by setting aside CR case number so and so. Full stop. It is needless to say that in view of the quashment of the aforesaid CR case, all consequent orders passed by the learned CJM shall stands set aside. Full stop. In MC, in view of the order passed in criminal petition number 40 of 2014, criminal miscase stands closed. That is one will be from here, huh? Meter.
That will be Lordship para 13, not page
Para
13.
13.
Para 13.
Para 13. I have given my green mark.
Lordship, may I pray one thing? Lordship has directed that to regularize the irregularities committed, if any.
If any.
If that-
If any.
if
If
any.
any. Okay, we'll look at. Yes. Yes.
My lord, case,
What are the earlier orders passed?
earlier order passed, my lord, may I give the certified copy? my lord?
Give any copies. Where is the complaint? Here investigation is not complete. Harshit submitted.
Others are already FR submitted.
Okay, where is the FIR?
My lord, the complaint was filed before the learned CGM on 19/3/2014. And your lordship will be pleased to find that at page number 13, my lord.
Okay.
Complaint, it is the type copy, my lord. And
This
paragraph
was lost by
on Mohiuddin, by Muhammad Mohiuddin Ahmad.
It is CM number here.
and then just let us understand first.
Yes,
So
my
it
lord,
was filed then.
thereafter, the same complaint was sent to the CGM. I mean, the said complaint was sent to the police station, my lord. And there one FIR was registered in the form of 382 on 29/3/2014, my lord.
That is page 81.
Yes, my lord. No, that page 81 is mine, my lord.
Okay. So where is that FIR?
That FIR is, yes, my lord, page 81.
Actually that
Yes,
page 81.
page 81, my lord. Correct.
Okay, now
Thereafter, my lord, that we also filed, I mean, the present petitioner also filed an FIR. And that was not registered. Then a complaint was made. Thereafter, it was registered. That your lordship will be pleased to see at page 86
86 by you.
by me.
Then what happened to that 86? That has been interfered.
Yes, thereafter the police interfered.
Page 86. Then
Thereafter, we came before your lordship for question of.
now what happened to this complaint? This was
Meanwhile, we came before your lordship for questioning of the complaint case. Complaint case.
this complaint at page 86 was lost by whom?
Merchant Maheshwari.
Amochan. Now this on the basis of FIR was registered, that has been closed already.
Yes.
Now what is your grievance against him? Let us understand.
My lord, the complaint which was filed, if I can take your lordship to the last paragraph of para number 13 and the first two paragraphs of para number 14, my lord, then from that it appears to be a total case of civil nature, my lord. It was a money transaction. May I read, my lord, that part?
Yes.
2 years before, the complainant, along with his family members, friends, relatives, and other people of the society, after being attracted by the advertisement made by the accused, invested a sum of rupees 56 lakhs 10,000
in presence of the witnesses, and on return, the accused promised to pay at the rate, interest at the rate of 12% per annum to the complainant till the return of the entire amount to the complainant. Accordingly, the accused paid from time to time along with the interest amount to the complainant, but after April 2013, the accused did not pay any amount to the complainant. Thereafter, my lord, on 25/2/2014, the complainant came to know from various sources that the accused company misappropriated the money taken from various customers and was on the verge of closing. On 26/2/2014, the complainant along with the witnesses went to the accused company and asked the accused to return the money lent by him. Instead of returning the money, the accused offered gold ornaments of same valuation to the complainant as he was suffering huge financial loss in his business. At first, the complainant refused to receive the golden jewelry offered by the accused as it was impossible for the complainant to show how they were in possession of so much of jewelry. Henceforth, the accused promised to provide the complainant retail invoice bill and asked the complainant to keep the jewelry and the retail invoice bill in his custody as mortgage till 7/3/2014. And that on 7/3/2014, the accused would pay the entire balance amount of rupees 46 lakhs due to him along with 12% interest per annum, which was estimated about 6,73,200 to the complainant after receiving the jewelry and the invoice bill.
Just a minute.
Finding My lord, the most important part is finding no other alternative. The complainant on 26/2/2014 took into his custody the jewelry and the invoice bill from 3640 to 3701.
My only thing is that some loss is there, my lord. That's 11 lakh something. Interest is I have not been paid.
But that itself says that this is a civil nature. Your only grievance is that file a suit against him. Because in fact, you have said that he said that I suffered loss. I'm not in a position to return. Please take ornaments. That is your allegation. Meaning thereby there is no initial deception in his mind. That's all.
For your lordship, my lord, it's very interesting otherwise.
No, it's not interesting.
No, no.
Thing is that you
is
had
that
money, he promised, you have invested money, and when he failed, then you have taken away all the ornaments. That is the facts of the case.
My lord,
Therefore, he has also lost an affair that you have taken everything were ransacked. We understand.
Yes, my lord. I'm not objecting this, my lord. Only one thing, my lord. This way, in one way, they are solving this in this way that you take this gold and it is ultimately solved. Thereafter, they are filing also FIR saying that I in robbery. However, the court has already
Therefore,
taken.
this is an abuse of the process by both.
Yes, sir.
That's why we have already set aside.
Yes,
Other thing is closed.
Yes.
Hard. Hard. Mr. Swenson, learned counsel for the one. The present application is filed for quashment of prosecution launched on the basis of prosecution being GR case number.
My lord, it is complaint case number.
No, but subsequently it was FIR was registered.
It was FIR. 281.
Let us see.
My lord, sorry, 382.
Being GR case number.
Nagaon PS case number?
No, that is Nagaon case. Where was search sheet is filed? What is the search sheet number? CR case number.
Only search sheet number is here, my lord.
Okay. In connection with Nagaon PS case number 382 under section 120 within bracket B/420/406 IPC. Full stop. The brief fact which are necessary for adjudication of this present petition are recorded herein below. The informant / complainant filed a complaint case before the learned Chief Judicial Magistrate Nagaon, which was registered as CR case number 293/2014. Subsequently, where is that order of the magistrate to register as an FIR?
My lord, that was given on the body itself,
Okay.
no separate order.
Though such case was recorded as CR case, however, the learned magistrate has forwarded the same to the local police station for registration of a case and for investigation. Accordingly, Nagaon PS case number
382.
Nagaon PS case number 382 2014 under section 120B/420/406 IPC was registered. Stop. The primary allegation as discernible from the complaint case / FIR is to the following effect. That the complainant with his family members, friends and relatives and other people of the society on being attracted by an advertisement made by the accused invested a sum of rupees 56,10,000 with the accused on a promise to return the accused an interest at the rate of 12% per annum till return of the entire amount invested. It is also stated in the complaint that the accused from time to time paid interest till the paid. However, after the month of April 2013, the accused did not pay the interest to the complainant. The full stop. On 25/2/2014, the complainant could learn that the accused has misappropriated money, and therefore on 26/2/2014, the complainant along with other witnesses went to the premises of the accused company and asked the accused to the money lent by him. It is also pleaded that instead of returning the money, the accused offered golden ornaments of same valuation to the complainant as he was suffering huge financial loss in business. Though initially the complainant refused to receive golden jewelry offered by the accused, however, the complainant subsequently received jewelry with invoice bill. And kept in his custody the aforesaid amount of rupees, gold ornaments of rupees 67,3200. Isn't that it?
My lord, that was the interest amount,
No.
6 lakhs.
46,10,000. Okay. On good faith, it is the further case that thereafter, on 4/5/2014, the accused and all the employees of the company left the place of business. And in the process, the petitioner has suffered loss of rupees 11 lakhs, a loss of 11 lakhs inasmuch as the accused has charged high labor cost on the golden ornaments, and the golden ornaments were of an amount of rupees 62,83,200. However, actual price was 51,15,978. 978. It is also on record that the accused had also lodged FIR alleging that the informant had ransacked the shop of the accused and taken away golden ornaments. And on the basis of aforesaid FIR, Nagaon PS case number 381, is not it?
My lord, that is
83.
yes,
Three,
my lord.
382, my lord.
382.
382/2014 under section 120B/420/406 IPC was registered, and what are the other 381? 381 is lost by whom?
My lord, this is 355. From page number 88, it appears that whatever the FIR was lodged by me, that was registered as
Okay.
FIR number
Full stop.
355.
It is full stop. Full stop. Mr. Swencho, learned counsel for the petitioner. Counsel for the petitioner. Write it from paragraph 8, paragraph 9, paragraph 10. Just change the name of the lawyers, okay? Paragraph 11. Full stop. Then paragraph 12, okay? Then paragraph 14. Then paragraph 15. Paragraph 16, okay? Now coming to the case in hand, the material available discloses that material available as recorded here and above discloses that admittedly the petitioner, the informant complainant invested money with a promise of return of 12% per annum. Admittedly, such amount was paid. However, such amount was such interest or any amount was returned till the month of April 2013. It is also an admitted position that the accused informed the complainant that due to his financial problem, he is not in a position to return the interest. However, in lieu of interest, he is inclined to give exchange gold ornaments. Full stop. It is also
of equal amount. By the way.
of equal amount. It is also an admitted position that gold was received by the complainant respondent number 2 after issuance of invoice, as the complainant number 2 was afraid that how he can explain of acquiring such gold without any invoice. Full stop. It is also an admitted position that it is the allegation that the actual amount of gold handed over to the petitioner was not actual compensation as regards money due, for the reason that the manufacturing and making charges were charged in an exorbitant way, and in the result, the informant/complainant has suffered a loss of 11 lakhs, 11 lakhs and odd, full stop. If the aforesaid statements are accepted to be correct in the considered opinion of this court, there is no ingredients of any initial deception or any ingredients of cheating or misappropriation, in as much as the loss incurred is a civil loss in view of the admitted position that it was an investment on expectation of return of interest, and that such return was also compensated to an extent by handing over gold ornaments in lieu of the cash. Therefore, in lieu of the cash, of the cost. Therefore, in the given facts of the present case, this court is of the considered opinion that the complainant has failed to lay the necessary factual foundation in the complaint to satisfy the prosecution of an offences under section so and so, so and so, so and so. In the considered opinion of this court, as recorded herein above, the dispute is purely a civil dispute, and there is no ingredients of criminal offense and a criminal color is given to a civil dispute. Then paragraph 21. Change the names. Paragraph 22. Last likhi diva. While parting with the record, it is made clear that the observation made in this proceeding by this court shall not be treated to be a comment on the merit of the claim of the complainant for purpose of any civil filing of any civil suit.
One line, my lord,
That I'll add, because even if accordingly so and so, charge sheet dated so and so, so and so, that's nothing will happen. Anything? What are the matters left?
12 and 13.
Huh?
12 and 13.
12 and 13.
6 and 7.
6 and 7. 6 and 7 and 8, these are criminal appeal.
Yes, 7.
We'll just take up first the criminal. What is this matter? That 14 and what? 16 and 17. No? Which is the Mr. Bothago's matter?
Bothagur is a 12 and 13.
And what is your Mr. Mohanto?
Same matter. I'm in the other side.
You are in the other side. 12 and 13. What are the issues here?
Dismissal from service, my lord.
Dismissal from service is
Petition, my lord, in the quashing of
item number
12 is for death.
Okay. You have been dismissed from service. Now, why this matter is before this bench?
along with criminal petition, this matter came
Earlier it was any direction. What is the criminal issue?
409 against the petitioner, my lord.
You have been convicted.
My lord, charge sheet,
The crossing, my lord, they
charge
got
sheet.
this stay order. After that, that is pending, my lord.
Okay. And in the departmental proceeding,
He has already been, my lord, found guilty, and for accordingly he is dismissed.
so why should we take up this matter?
That is why that
Item
can be.
13. Suppose we quash this thing, that will follow whether that is similar or not, we are not going to
But the
take up.
criminal case and the departmental
No,
court cannot be
no,
same,
no,
my
no.
lord.
Where is Bothagur?
Court number 17.
We are not taking up item 13.
Charge sheet.
Let him come at 2. So only remains is 12, 13 and 7 and 8. Anything, 18, 19, 20, 21 may be doubtful. Today we are rising a little bit early. We'll come back at 2. Let us see.
Yes, sir.
By 3, we'll have to finish these matters whatsoever. So we'll sit for 1 hour only.
Different, both are different.
Different, and therefore,
Since your
suppose we allow your criminal petition. That can be a point of argument, point of determination for
even
subsequent.
that will not be a point of my argument, but your lordship, since it is 2000.
But I'm not taking up this writ petition matter. I will take the only criminal matter. Then thereafter, it will go to the appropriate bench. But today not possible. We have some.
Then, my lord, that will be better if it is lordship today it is segregated, then.
No, we are not segregating today. We are not segregating
Yes.
today. Let us understand what the criminal matter is. Yes, everybody, today not possible.
On 5th, your lordship.
5th. This criminal petition item number
Item number 12 and
12,
No, no.
12 and 13 on
5th, your lordship.
5th of December, Mosumi? 5th of December. 5th of December, Mohanta?
Obliged.
And what are the other matters?
Lordship, item number 7 and 8.
7 and
7
8.
and 8.
You are a legal aid counsel, isn't it? Okay, 7 and 8, which year? Inside jail?
2011. Lordship, suspended, Lordship. The
Suspended.
order is-
2011. Okay, it has December, give a date.
11, 12, 11.
9th of December.
Lordship,
Possible?
Lordship, obliged, deeply obliged, Lordship.
And yes, madam, your matter.
19 and 20, Lord.
POXO? No, forest, wildlife, okay. 19 and 20, when? This is of 2019, they are inside or outside?
They're inside jail.
Inside, so it will have a preference. So what was the total conviction?
Total conviction was for 7 years.
But already they are
They
inside
were in jail
for
for
5 years,
9 months.
9 months. Give a date,
Lordship, status report was called, but I think it has not
not there.
come. Can it be given in January, Lordship, if possible? For
January.
December, I'll be on leave on
Okay.
December, if possible,
Okay,
Lordship.
January. This give these 2 matters in January. 7th of January.
Be obliged, Lordship.
Item 21, my lord, I am for legal aid counsel in this matter, lordship. Punishment is 10 years.
Part 2, 304, part 2. Yes, when? 2019 again.
Is January and it
January, give it to January. 10th of January.
is he hearing this?
No, it is man should be for here, always hearing. Every day is a hearing day. Today we could not, but otherwise you are every day.
Other matter, lordship, part third matter is supplementary.
Part third matter we
Yes.
have already adjourned.
Oh, yes, I am sorry.
Already adjourned, we have
I am
fixed a
not
date
present at that
because they are filing an affidavit.
Yes.
Okay, next week we have fixed a date. Any other matter
Okay.
left? 18. This is also 6 years, 6 months. As Islam, amicus. Anyway, give a date in January. Before Bihu. 8th of January. Due to paucity of